Everyone to today's part of Animal Law Week, and the topic is animal personhood, rights of nature, and the Estrellita constitutional case in Ecuador. I'm Kristen Stilt, professor of law and faculty director of the Brooks McCormick Jr. Animal Law and Policy Program. I'm going to very quickly introduce our other panelists and very, very brief background, and then we're going to turn into me asking them questions about the case. We are on a firm schedule, even firmer now, so I'm going to introduce our panelists very briefly, not giving them full due of all their accolades, but in the interest of moving along. First, Hugo Ashaveria is an Ecuadorian attorney with 20 years of experience in environmental law and rights of nature, and indeed, he is the preeminent rights of nature lawyer in Ecuador and a key part of our team. Macarena Montes is an attorney and doctoral researcher at Pompeu Fabra University in Barcelona, and also a rights research fellow here at Harvard Law School. Steve Wise, founder and president of the Nonhuman Rights Project, has written extensively on the topics, habeas corpus and animal personhood, and of course is the founder and president of the Nonhuman Rights Project. All right, so let's jump right into our case today. All right, here we go. So what is this case that we're talking about? Ana Beatriz Urbano Proano had a woolly monkey as a pet, and she named her Estrellita. She lived in her home for 18 years. You can see from the map of Ecuador here where it's located, and also how significant its terrain is, located right around in the Amazon basin. So a very, very rich area in terms of species, including primates. So environmental authorities forcibly seized the monkey from her home on the grounds that possessing a wild animal is prohibited in Ecuadorian law. Ana brought a claim of habeas corpus against the authorities to return Estrellita to her. A habeas action, as you know, would require a court to order a detained individual to be brought to court so it could be determined if the detention is lawful or not, in which case the person is released. But Estrellita had died within a month of being relocated to the zoo, which is where she was taken. And so the habeas claim could not be heard. But this case, through various twists and turns that I won't go into, made its way all the way to the Constitutional Court of Ecuador, which specified 3 questions that the court wanted to consider. And here are the 3 questions. Can an animal be considered as a subject of rights? What is the scope of the writ of habeas corpus in relation to the protection of other living beings? And can non-human animals be considered as a subject of rights protected by the rights of nature? Now, you may be asking, the rights of nature? I never saw that in the U.S. Constitution, and of course, we do not have anything like that in our Constitution, but Ecuador is quite unique in that regard. So let's just look together at Article 71, although there are several articles dealing with rights of nature, to give you a sense of the one of the constitutional provisions at stake in the case. Nature, or Pachamama, where life is reproduced and occurs, has the right to integral respect for its existence and for the maintenance and regeneration of its life cycles, structure, functions, and evolutionary processes. All persons, communities, peoples, and nations can call upon public authorities to enforce the rights of nature. To enforce and interpret these rights, the principles set forth in the Constitution shall be observed as appropriate. The state shall give incentives to natural persons and legal entities and to communities to protect nature and to promote respect for all the elements comprising an ecosystem. All right, so we were very intrigued by this case and thought it was potentially extremely important. The Nonhuman Rights Project, as you will hear more, is very interested in legal personhood and the use of habeas corpus. I personally am very interested in animal rights, legal personhood, and the rights of nature. And so we teamed up with myself, Macarena, who I introduced, Steve Wise, who I introduced, and Kevin Schneider, the Nonhuman Rights Project Executive Director, drafting the brief, and amicus brief, and I will say that Hugo, of course, was central to all of this because he initially contacted us saying, we have an extremely important case here, and I think that both of your organizations will have something very important to contribute. So we're very grateful, Hugo, for bringing us together and prompting us to work on this amicus. So now, without giving away the holding in the case, I'm going to return to the 3 questions that the court asked, and now turn to my panelists for some of their commentary. And as we go through it, you'll find out how the court decided, what we argued, and what it means for the future. All right, so I want to turn to Hugo first and ask, can you place this case in the larger context of what's happening in Ecuador? This case didn't come out of the blue as a single interest in both habeas for animals and the rights of nature. Why these questions from the court and at this time? And if Hugo, you want to start, and Macarena and Steve, you're welcome to jump in. But Hugo is, of course, our expert here on all things Ecuadorian. You're still muted.
Okay.
There you go.
Thank you, Kristen, and greetings from Ecuador to the panelists and to the audience. Indeed, the court decided that non-human animals are subjects of rights, that is, right holders, protected under the rights of nature as guaranteed by the Constitution of Ecuador. This judgment is the 6th one, number 6, issued by the Constitutional Court of Ecuador, specifically on rights of nature. The Constitutional Court is the highest body on constitutional control and interpretation in the country, much like the Supreme Court in the US for purposes of constitutional review. This judgment was approved by 7 out of 9 votes. So it shows coherence and approval by nearly all the judges. That's the first idea. The second idea, important to give even a broader context, back in 2008, Ecuador recognized nature as a new subject of rights. So it's a new rights holder. In 2019, some 13 years later, the Constitutional Court began selecting cases to address complex issues of social interest in the country, namely gender issues, the rights of women, terminal diseases, and nature. The court indeed included nature on this effort. As a third main idea to share is that Ecuador is one of the 17 mega diverse countries in the planet. Very high biodiversity rates are found here. So the cases selected by the court truly address complex issues on sustainable development in fragile ecosystems or in the habitat of critically endangered species. So these are very difficult juridical problems. And these cases included mining projects, hydropower plants, oil extraction, and agro-industrial activities. The first 5 judgments of the Constitutional Court on rights of nature were issued between June and December 2021, last semester. In these judgments, the Constitutional Court addressed the rights of nature very, very seriously. It made decisions based upon the foundations of constitutional law, concepts on addressing rights of nature from a context of the rule of law, the principle of legal reserve, the concept of legal security. But it also addressed, you see in the decisions, in the judgments, much biology and engineering. So it included science and engineering in their arguments. The court set standards never set before in judicial decisions in Ecuador, and I must say in Latin America. Higher standards than those provided by environmental law. If there is time, I will really like to go deeper in this topic, because it is important to make the difference between environmental rights and the constitutional rights of nature. In this context, in January 2022, the court issued its judgment in this specific case, addressing the legal status of non-human animals. The legal status of non-human animals. For these 4 reasons, there was uncertainty as to how the court would address this topic. Not an easy topic, indeed. First of all, Ecuadorian Civil Code classifies non-human animals as objects. Okay? That it follows the civil law tradition. Secondly, Ecuadorian environmental law approaches animals as objects of protection. That is the doctrine on animal welfare. Third, the leading interpretation on rights of nature approaches nature in a restrictive manner, sees nature as a place, for example, ecosystems or rivers, but not including the parts, the elements, or the components of nature. So that was the legal main doctrine. And fourth, in Latin America and certainly in Ecuador, the prevailing concept when addressing animal law is the concept of sentient being. So this is the context in which the court addressed this case and really made this important decision, classifying animals as subjects of rights under the umbrella of the constitutional rights of nature. So as you can see, the court transcended the former arguments of civil law, of environmental law, and even of animal law. And now this topic is a constitutional law topic in the country because of the rights of nature. So for now, I will stop there, just announcing that the court also said that this will require a profound legal reform in the country, which the verdict calls for. So we will have legal reform in the coming years in order to for the legislation to match with this jurisprudential standard. Thank you.
Thank you, Hugo. So as you explained, going into the case, the jurisprudence, the prevailing beliefs were really stacked against answering these questions in the affirmative, which of course is what we wanted, that animals were subject of rights, that habeas was appropriate, and that they could benefit, they could derive rights from the rights of nature. So you've really told us how uphill a battle we were facing, and we'll come back around to this. But for now, I want to turn to Steve and have you tell us a little more about how you read the decision in terms of recognizing animals as subject of rights and the habeas portion. Of course, the habeas question is a little bit convoluted because Estrellita had died prior to the case, and yet there's still habeas language in the decision. So what do you make of the habeas commentary or holding by the court? Favorable, not favorable? What's your assessment?
Well, from the first thing that we saw, we understood that the very thing that we were trying to work on, the question of whether habeas corpus was going to be involved when the entity who is dead, and we don't know anyone in the history of the habeas corpus through centuries of centuries where someone who is not dead is going to is somehow trying to get a rid of habeas corpus. So well, we weren't totally shocked when the court said that they weren't going to do that, and the amount that they talked about was very small compared to the thing that Hugo was talking about. We only can focus on perhaps 6 or 7 paragraphs in which they actually talked about habeas corpus, which, by the way, was interesting to me because I didn't know that they they might simply use it in one paragraph and just say they're dead, so you don't do anything with habeas corpus when you're dead. But they didn't. They said that you don't get habeas corpus, but they seem to want to talk about it in some way, and it's not 100% clear to us. But what it did say was that it seemed to indicate that habeas corpus could be an appropriate action for a non-human animal. So for us, that's enormous. That's some of the work that the Nonhuman Rights Project has done for a long time. And also, the second main thing was that, well, I guess, first of all, when they're talking about the rights of wild animals, they talk about having their own inherent rights, and we're not exactly sure what that means, but they say if you're a right of animals, you have your own inherent rights when they're talking about habeas corpus. And they're also talking about the fact that they seem to say that when a non-human animal, especially a wild animal, that they can possess rights that may derive from other sources that are addition to the Constitution. And that was the part that interested me as well, because we're not only fighting about what's going on in Ecuador, but then, of course, we're also fighting cases in Israel, India, throughout the United States. And the Ecuador court does seem to say that, for whatever reason it chose to do it, that habeas corpus was something that was still going to work for a non-human animal, and that a non-human animal who is seeking a habeas corpus can get rights that derive from sources that are in addition to the Ecuador Constitution. That's almost all it says in the 6 or 7 paragraphs about habeas corpus.
Okay, great. Well, it's something, right? So it's certainly important. And then, of course, most of the decision is about this big question whether animals can derive rights under the heading of rights of nature or be beneficiaries of the rights of nature. And as Hugo said, customarily, nature had been seen as a place, not component parts. And so there was a real challenge here. And Macarena and I, we all worked on the brief together, but we worked on this part in particular. And so let me turn to you to explain what's the challenge that we faced in arguing that one individual woolly monkey should benefit from the rights of nature. So if you want to talk about that first, and then tell us, did the court buy our arguments?
Okay, thank you. Can you guys hear me? Yeah. Okay. So Estrellita's judgment has important implications for animal rights in Ecuador. So first, as Kristen said, the court recognized Estrellita as a subject of rights protected by the rights of nature. So the court acknowledged that animal rights constitute a specific dimension of the rights of nature with its own characteristics. Second, one of the most important arguments we made in our amicus brief was that species are made up of individual animals. So what happens to one animal can significantly impact the species. So it would be arbitrary to decide the number of animals needed to activate the rights of nature. Would 2 animals, 5 animals, 10 animals be enough to activate the rights of nature? So even though this argument sounds logical, it was a complex argument to make due to the Constitutional Assembly's debate on the rights of nature in Ecuador, scholarship on environmental law and rights of nature, and the Constitutional Court's case law, which had always focused on species, not individuals. Although the focus on species protection has been insufficient, considering we are going through the 6th mass extinction of animals. But luckily, the court decided to challenge this traditional view and argued that animals are not only protected from an ecosystemic perspective, but also as individuals. So this change is a huge win for animals because from now on, the rights of nature provisions will be used to protect individual animals that are taken from their habitats. For example, Maybe they are taken for the illegal pet trade or zoo trade or hunted for their fur or as trophies, among many other cases. So third, the court outlined some rights that animals hold. These rights include the right to exist, the right not to be hunted, the right to the free development of their animal behavior, the right to freedom, the right to habitat, among many other rights. However, it is too soon to know how these rights will be applied to concrete cases. And it is also too soon to know if these rights apply to some animals or all animals. Some of the rights mentioned by the court refer to animals that live in the wild, but other rights, such as the right to food, to health, to live in harmony, to develop their behaviors, apply to all animals. Fourth, the court also ordered the Ministry of Environment to develop a protocol that considers the circumstances of captive wild animals to ensure their protection. So this means that the environmental agency will proceed according to a confiscation protocol that considers the specific circumstances of that captive animal to avoid repeating what happened to Estrellita, as putting animals in zoos is not always the best option for the animal. Finally, the court ordered the Ombudsman and Congress to prepare a bill on animal rights based on the ruling. So hopefully this law will include and develop the rights outlined in the judgment. So as we can see, the ruling has important practical consequences for animals in Ecuador. From now on, individual animals are protected by the constitutional provisions on the rights of nature. Additionally, as a constitutional court, the highest court in the country, has recognized animals as subjects of rights. Government, Congress, and other courts should act accordingly. It would be weird for a law to come out now saying that animals are just property, you know? Moreover, the writ of habeas corpus can be appropriate for animals depending on the specific circumstances of the case. And if all goes well, captive animals will have a protocol that considers their circumstances when confiscated. So this decision on where they should live should consider what's best for them. And finally, also, if everything goes well, Congress should pass a bill on animal rights based on the ruling that also should improve the protection of animals in Ecuador.
Great, thanks so much. And I think, we're all, one of the big questions, as you noted, is what's the scope in terms of species? So Estrellita, as a woolly monkey, was a wild animal. Of course, she had been in captivity for 18 years and didn't really know what life in the wild was like. But what happens when we're talking about more of domesticated animals? What about wild animals that might be bred for food? So a kind of a wild animal, farmed animal hybrid. Those are the questions that, of course, will emerge with time. Hugo or Steve, do you want to say anything else? Jump in on the question of the rights of animals derived through rights of nature. Add anything to what Macarena has already said? If not, we can go on to another question and then take questions from the audience. You're muted, Steve. Steve, you're muted. And you're still muted. See. Hugo, why don't you jump in?
I just want to add that there have been important precedents issued by courts in Latin America, namely in Colombia, Brazil, and Argentina, worldwide known decisions. However, the Ecuadorian decision now ranks first because of, at least for three reasons. First of all, this decision went beyond animal law concepts in Latin America of sentient beings. We are not talking about sentiency. We are talking about animals as right holders under the umbrella, and this is a constitutional matter. Second, this decision is issued by the highest judicial body in constitutional interpretation that has the power to even ask for legal reform. Okay? So, and third, this is interesting. If you compare these decisions with the ones issued by the Argentinian courts on habeas corpus in favor of animals, this one comprehensively addresses the topics. For example, the role of habeas corpus as a guarantee in favor of animals, and also the legal status on the animal. So I think this is, this decision will set. It's very important and will become very influential in all the courts in Latin America.
Just one last point. It'd be great for you to speak to Hugo, and then we'll take questions from this room. If that's okay. Yeah.
Steve's unmuted now.
Okay. Yeah, Steve, want to say something?
Hear me, or if I am at all? It's Steve. Okay, so one of the things that the court the court considers it appropriate to point out that the rights of a wild animal must be protected objectively, taking its life, freedom, and integrity as their own inherent rights. And that's what I can't figure out, was whether they're talking only about wild animals or they're talking about non-human animals as well. I just have I just can't figure it out.
I think we'll have to wait to find out. But the one thing I did want to mention, and you might want to weigh in on this, and then thinking of your questions, is that people may be thinking, okay, that's great, but where are the rights of nature, right, for animals to come under the rubric of it? And I guess what I want to say is that it's not as obscure or niche as it may seem. In fact, I think it's fair to say that the rights of nature is an expanding movement that exists even in the U.S. There have not been big successes here yet, but there have been attempts at making Lake Erie a legal person and other things that we would say fall under the rights of nature. So, Hugo, in about 30 seconds, do you want to say something about the trajectory that you see of countries and other entities adopting rights for nature or constituent parts of nature?
This is an emerging trend. It's now being replicated in the in the Constitution of Chile, in the legislation of Panama. But more importantly, at least in the case of Ecuador, this is not an environmental topic. This is not an animal law topic. This is a constitutional topic. This is the most important contribution of this decision. The issue of animals, of the legal status of animals, is now a constitutional matter.
Okay, great. All right, questions from this room, or are questions that may come in through the chat? We have just a few minutes, but I'm happy to take them. Yes, please, Saskia.
You just repeat the question.
Yeah, I'll repeat the question. Go ahead. Okay.
So I have two questions. First of all, how important is the concept? So where I'm from, informative constitutionalism, especially in Latin America, is a big topic. So I'm wondering how important that context is, and maybe that's the reason. So in Switzerland, we have animal dignity in the constitution, but the highest court would never derive from that animal rights or anything. So maybe that's the reason why in America or in Burmese Switzerland we don't see these fantastic judgments, and maybe in Latin America we do. So I'm wondering, about that. And then secondly, of course, this is a fantastic judgment, but I'm a bit concerned when I look at animal rights jurisprudence globally, Pakistan, India, Argentina, Colombia, etc., that it's typically these magnificent animals or human-like animals or wild animals in this case. And I'm wondering whether we see a new rift here between wild animals and the animals that we exploit most as a society. And the Constitutional Court of Ecuador kind of mentioned that in its judgment, that it basically kind of exempts the animals we use for food from its reasoning. So I'm a bit weary of that.
Okay. Did you hear any of that? Do you mean to repeat it? So very quickly, one is, could this only have happened in Latin America, where the idea of a more transformative constitutionalism exists, as opposed to a more conservative constitutional jurisprudence or ethic, such as in Europe? And then, does this case, while having its positives, just further entrench the differences between protecting wildlife and not protecting farmed animals, for example?
Alas, I don't know the answer to these things. These are very hard for right now.
Macarena, go ahead.
So regarding farm animals, as I mentioned, we don't really know yet, but the court did list a long list of different rights, and many of those rights are applicable to farm animals. For example, the right to food, the right to health, the right to live in free of mistreatment. Some of those rights even sound similar to the 5 freedoms. So I imagine that we have to see on the next judgments how these different rights are going to work. But the court, I do think that the court listed some rights that are applicable to all animals. And I think the court also listed some rights that are applicable to animals that live in the wild. For example, the right to habitat, the right not to be hunted. And so, but the court wasn't so specific to saying like the right to hunt it, to not be hunted corresponds only to wild animals. No, the court didn't say that, but it did recognize animals in general as subjects of rights. And then talking about Estrellita's case, it recognized Estrellita as a subject of rights protected by the rights of nature, and then listed many rights. The court even said that animals have the right to life, the right to exist. So it's really impressive that the court even said this. The court said that animals have the right to freedom too. But I think we have to wait to see the next judgments. But I do think that some of the rights that the court mentioned are applicable to farm animals.
Okay, last word to you, Hugo. We got really 1 minute before a class comes in. So please, Hugo.
The wording of the judgment suggests that the court wrote this decision thinking it will be the first of many others to come. And it clearly anticipates that these ideas are not limited to wild animals, but to all animals in general. And regarding the first question, this is happening in Latin America in several contexts. So Latin American follows the civil law tradition. So it can happen anywhere else where civil law tradition sets is the setting as a legal system.
Okay, thank you all very much. I'm going to share the last slide, which provides some information if you want to probe these topics further. But thank you for being patient with us. We still got in a lot of conversation, and we hope to have another one, perhaps in conjunction with an Ecuadorian university that might be longer. We'll certainly make that known. So thank you, Hugo, Macarena, Steve. Thank you, Kevin Schneider, for participating as one of our authors as well. And thank you all for being here.
Thank you, Kristen.
Thank you, Kristen.